So we are back with Hillary Hux, and we are going to be talking about all of the things in terms of just divorce and alimony and things of that nature. We have a ton of Q&A questions here. So let's start here. What are the steps to obtaining a non-contested divorce in North Carolina?
So most divorces aren't contested. What you do is, and you can do this yourself, it's maybe a little bit more difficult, but you would file a complaint for absolute divorce. That's certainly something a family law attorney can help you with, but you file that initial complaint, you allege that you have been separated with the intent to terminate the marital relationship for at least a year. And then the next step is to have that served on the opposing party, your spouse. After that, then they have an opportunity to respond. That's 30 days automatically, and you can almost always get an extension of another 30. If there doesn't appear to be any issues of fact, basically both spouses admit that they've been separated for a year with the intent to end that relationship, then you file a motion saying just that and schedule it for a court date.
Gotcha. Now, someone asked, if a man owns real estate prior to marriage and the marriage then ends, is the wife entitled to the property?
Generally, no. The simple answer is no. Now, if the marriage has paid down a mortgage on that property, or if the marriage has made significant improvements to the property, they did a kitchen renovation during the marriage, then there are some nuances there, but the simple answer is no.
Someone said, I am a grandma, I have it right here, and I wanted to know if something happens to my daughter. Sorry, we're getting a lot of questions here, so it keeps bouncing back up. Let's see this.
Yeah, no problem.
I'm a grandma, and I wanted to know if something happens to my daughter, will I be able to get my grandbabies even if the dad is still alive?
Generally, no. You would have to allege that dad is not fit to be a parent or has acted inconsistently with his constitutional rights to initiate a custody action. If there's already an existing custody action, then she should try to get involved in that. She should try to become a party to that pre-existing action, because that's going to change the answer.
Gotcha. My mom is executor of my brother's estate. She needs to know where the insurance policy money is that is needed to pay the funeral home. What steps does she take?
Oh, unfortunately, I am not well versed in estates. I pretty much limit my practice to family law, divorces, child custody, that sort of thing. I could definitely refer her to a colleague, but I wouldn't trust myself to answer that question.
No worries. So what happens after a person is served with divorce proceedings and they never respond?
So if the request is just for the divorce itself, just for absolute divorce, and they don't respond, pretty much the divorce is going to be granted. It's just a matter of waiting out the requisite time periods. If there are other claims attached to that, so claims for child custody, for property division, then I'm much more concerned, because some things could happen without them being involved. The court could make awards as to child custody, as to certain items of, personal or real property. So I would definitely recommend that they respond or at least seek some legal advice before making a conscious decision not to do anything.
The next question here is, I was married for 25 years. I've been paying alimony for 14 years. What is the law on being able to stop paying?
So if your court order is indefinite, it doesn't set a date for the termination of alimony, then if there's been a change in circumstances, you can file a motion to modify or terminate alimony, alleging that some changes have occurred. Now, a lot of alimony orders already set a time limit, so check back and take a look at that and see what that duration is. Maybe your alimony obligation expires after 20 years. You want to be aware of that.
Gotcha. Well, we have several more questions to break down and answer. We'll be right back after the break.
Okay.